them in 1976. So 40 years ago, Kentucky abolished commercial bail, and is actually unlawful. It is a crime to do what they're doing here in Maryland and Kentucky. It is unlawful, as it should be. So it's actually, you would go to jail for profiting off of a bond. So, we outlawed them in 76. What we didn't do in 76, or 86, or 96, or 2006, or 2016 is eliminate money. So the statutes still allow for cash bond. The difference is, instead of paying a fee that's non-refundable to a private entity, the money is paid to the court and held in escrow and then returned to the defendant when their case is over. Regardless of the outcome, whether they're convicted or not, that money is returned upon disposition of the case. So again, that's where Kentucky started in 76 with pretrial. We have 287 employees, including myself, and we're able to provide pretrial services statewide to all counties within 24 hours of arrest. There's an interview and an assessment conducted by pretrial officers. We do that very efficiently, and it doesn't cost a lot. My entire budget to run this program is only $13.4 million. And that's to provide pretrial service to every person arrested within 24 hours. Oh, another thing that we're unique is we are part of the judicial branch. We are a state entity. We work for the courts, not the individual counties. So my staff throughout the state, they actually work for the courts, not for the local judge. They work for the central office in our capital, so since they work for me, even though they're housed in individual counties. Why is this important? Our county jails are funded by the counties. They don't have to pay for pretrial, yet every person that's released pretrial, they don't have to pay for it, and they don't pay for us. So it's state funds that fund the pretrial program, but yet we avoid substantial costs at the county level with the jails. And just to give you an idea of how many people are going through Kentucky pretrial, this is data for just 2 years. So of the 287 staff, including myself, we interview and assess 320,000 defendants. And of those, almost 76% were released. It's like 75.6. And keep in mind, these release rates are for everybody that comes to the jail, period. You get booked into a jail pretrial, that's what percent were released on pretrial release. If you exclude those that have other issues, such as they may be serving time on a sentence, they might be serving a 60-day sentence, if you take those out, our release rate jumps up to close to 90%. Because there are a certain percentage of defendants that have other issues besides their current charge. So even if they obtain recognizance on their current charge, they're not physically going to be released. So if you take that out, our release rate jumps up to about 90%. But look at the number that are still in custody. It's like 1%. And if you look at the number that their cases were disposed of within, they may not have got pretrial release, but their case was disposed of within 72 hours. It's another large percentage of these people. So in a sense, if you want to look at who's detained in Kentucky, that would be about 20%. The 19% that were unable to make a cash bail, and the 1% that are still held in custody. Now, granted, it's not perfect. We don't have bail bondsmen, but we're not perfect because we have money. And we don't have anything in our statutes that allow a judge to hold somebody in jail without bail if they're deemed dangerous. Our Constitution basically says all offenses are bailable except capital offenses. So technically, if we were to follow the law as it's written in Kentucky, there wouldn't be anybody in jail but probably about 10 people that are currently right now on trial for a capital. Not just murder, but a capital offense. So again, we unfortunately, knowing that it's unconstitutional, judges have no other recourse but to set a money bond that someone can't make if they want to detain somebody. And everybody knows that's wrong. So we're ripe for litigation as well. And I think that in the near future, meaning maybe this next session, that will be addressed. And hopefully we can just eliminate money altogether and go to a system where you're either detained or released. Go ahead, next slide. Just looking at risk level, I wanted to mention this because there was some talk earlier about risk assessment. The only thing I would caution about risk assessment is if you had a blanket rule that all low risk should be released and all high risk should be detained, you better be prepared to be holding people charged with very serious crimes and releasing operating on suspended license, misdemeanor shoplifting, because the risk assessment used in Kentucky is based solely on one's criminal history. The current charge is not factored into that. So you could be charged with, and I can tell you that the highest risk for flight and reoffense in Kentucky is the charge of operating on suspended driver's license. Why? We suspend people's driver's license for every reason imaginable. You don't pay your child support, they suspend your license. You steal gas, you suspend your license. You don't pay for your insurance. And we have no public transportation. So it is a huge charge, and the majority of those charged with that do have high failure to appear rates. So again, I just caution you on that, is to make sure that any type of reform includes discretion, because of the 56% of high-risk people that were released,